Rule of law under the British Constitution. Introduction. Rule of law means the supremacy or dominance of law. The rule of law in England is the outcome of centuries of development. According to Professor Dicey, though there is no separate act in England to guarantee the fundamental rights of the citizens, as is the case in the USA, British citizens enjoy maximum liberty due to the rule of law. The very root of English law depends on the rule of law. Meanings of the rule of law. A. Black's Law Dictionary. Rule of law means a substantive legal principle. B. According to Bluntly, rule of law means that the law of England rules the country and not the arbitrary will of any individual. The law is supreme, and no one can claim exemption or immunity from it. C. General meanings. The rule of law implies that no one is above or below the law. All people are equal in the eyes of the law. If any person violates the law, he should face the case in court. Dicey's exposition of the rule of law. The English jurist Dicey has given a description of the conception of the rule of law in his book Law of the Constitution, first published in 1885. He gave the following meanings to this concept. A. No arbitrary punishment. No man is punishable or can be lawfully made to suffer in body or goods except for a distinct breach of law established by the ordinary court of the land. So all persons accused of an offence should be tried in an ordinary court of law in an ordinary legal manner, and no one is to be deprived of his life, liberty, or property. B. Before law equality, equality in the eye of law. Secondly, the rule of law implies that in the United Kingdom, every citizen, rich or poor, high or low, is subject to the same direction and the same courts of law. It's because UK law does not distinguish between acts of government and those of ordinary citizens. If any public official does any wrong to an individual or exceeds the power vested in him by law, he can be sued in an ordinary court. C. Judicial decisions. Finally, the rule of law means that the general principle of the Constitution are the result of judicial decisions determining, formatting, the rights of private persons in particular cases brought before the courts. Instances, examples, of the rule of law. The following are important instances of the rule of law. A. The right to personal freedom. People have personal freedom in England. No person can be arrested without lawful reasons. B. The right to freedom of decision. The people of England have the right to freedom of decision. The media is independent. Everyone can criticize the policies of the government. C. The right to a public meeting. People have the right to attend public meetings and form political parties. D. Ministerial responsibility. Ministerial responsibility is an important instance of the theory of the rule of law. If one minister does wrong, others become responsible for his actions. Exception. Since Dicey explained the concept of the rule of law, many changes have come over the world, and even in Britain, a country that can boast of the rule of law, the concept had to face the challenge of the changing times and admit certain clear limitations. Following are the exceptions to the rule of law. A. Suspension of the rule of law. During an emergency, the government may partially suspend the rule of law. B. Judges of the courts. Judges cannot be held responsible for anything they do in the official course of their business. C. Queen is above law. The Queen is not amenable to any court of law. She is above the law. She is immune, protected, from all civil and criminal traits, character. The Crown is not responsible for the wrongs done by its officers. The Crown is not responsible for the wrongs done by its officers. A government official is personally responsible for the mistake made in his official capacity. E. Foreign rulers. Foreign rulers cannot be tried by any court in England for any wrong committed by them. F. Diplomatic representatives. Diplomatic representatives cannot be tried by any court in England. G. Servants of the Crown have no protection if dismissed. If the Crown dismisses his servants, they have no protection against the Crown, even though they are dismissed without just cause. H. Public officers. Public officers are not liable for their subordinates' wrongs because certain acts have conferred some privileges and immunities on public authorities. J. Time of proceedings against the servant. It is essential to take action against public servants within 6 months from the date of the cause of action regarding any excess, neglect, or default of public authority. The right of action expires after 6 months. K. Justice of peace. The justice of the peace is not liable for any act if the act is not wrongful or malicious. L. Trade union. Trade unions in England enjoy a lot of immunity, protection, from the law. M. Cancellation of citizenship. If the citizenship of someone is revoked, it cannot be challenged in any court. N. Power to the police. The Public Order Act of 1916 gave the police the power to regulate or prohibit public meetings and processions, marches or parades. It can also declare drilling and the wearing of unauthorized uniforms illegal.